Everyone's here. Let's go ahead and proceed. You each have 15 minutes, and the appellant may reserve 5. Just let me know.
Thank you, Your Honor. Your Honor, please support Attorney App.No on behalf of the appellant, and I would like to request 4 minutes of hand.
That's fine.
Thank you. Your Honor, if it pleases the court, what this issue comes down to, what this case comes down to, is the appellee in this case having, being a very well-educated, experienced, employable party who the court improperly attributed $0 in income to, for the purposes of child support, as well as spousal support.
Well, now when you say $0,
yes,
the court said the last job she had was
$27,500, and then what the court did was it took her testimony. It was based on testimony alone. It's not based upon any kind of evidentiary support that the child care costs for 3 children, all of them are in school. I believe at the time we're dealing with a 2nd grader, a 5th grader, a 6th grader, would be approximately $2,000 a month for a grand total of $24,000. So
you're saying because there was no documentation, her word was insufficient to...
it was a combination of the two, Your Honor. First of all, the dollar value itself seems excessive, especially when we're looking at 3 children, all of them are at the Twinsburg schools at the time. Second of all, there was no additional foundation for what that child care would involve. So for example, and I'm speaking a little bit from experience here, but regular so child care that would be during a normal workout day, we'll call it 8 o'clock in the morning to 6 o'clock at night type of work, child care, versus what this would actually be, which would be after school and summer break care, as well as potentially sickness days, teacher in-service days, things like that. So there was no breakdown as to what this child care would have actually involved. That's obviously the documentation we did was support. It was also an approximate. I think if you look at the transcript, I forget the page number, Mrs. Sayoc indicated that it was approximately, there was no specific dollar value attributed to what the actual cost itself would have been. Once again, dealing with children, especially at this age, their needs can vary as well as their the amount of need. And without knowing, for example, what this child care would cover, which should have been provided some kind of documentation, whether it be an estimate from the child care facility itself, whether it's even information off the website. I mean, something just basic to provide what we're talking about for child care, especially when we're also dealing with the oldest child being in the 6th grade. Would that child care continue, or would it go to just an after school or something?
Was there testimony about the number of hours that would be needed, or was there just generalized testimony as to cost per child?
Generalized testimony as if mother returned to the workforce, what the cost would be, but there was not specifically what that cost would incur. So for example, and I hate to use myself as an example, but our child care goes in the morning and afternoon. My children, my wife and I both work, so consequently we drop off our kids and we come pick them up after the workday. In this case, what it appears it would be whenever Twinsburg City Schools let out until whichever parent comes and picks them up.
Before and after school care?
Before and after school, potentially before and after school care. I believe there was testimony from Dad that he actually had flexible hours through his work at the time, and so he would have had the ability to perhaps shift changes. So for example, it may not have needed the before school care if Dad could have adjusted his schedule. Mom, I know, had testified about her prior employment, and I want to say it was at Ohio Savings Bank, and one of the reasons she picked that position instead of the position at the law firm was because it allowed for some flexibility with the hours. And so there perhaps wouldn't have been, let's say, the before school care, and the after school care could have also possibly been adjusted, but there was also no effort placed by Mom to engage Dad in the conversation for the transcript. So, where costs could have been alleviated, there was not even an effort to do so, at least based upon the transcript as it is. And so when you're taking that, and then you add into the courts essentially negating any financial responsibility on behalf of the mother, combination thereof, you know, that we do know that she had been employed, she had a bachelor's degree, she had a law degree, she had been a law licensed attorney.
But in fact, I think the record shows that there was an initial agreement that she would be a homemaker taking care of the children.
Correct, I think my
Which
recollection.
took her out of the workforce for a substantial period of
Correct.
time.
And Judge Whitmore, I'm not saying there's anything wrong with that, but
No, I'm just trying to clarify your
Yeah.
position.
yeah, and that she had come out, but she still does have that base of education. She does have the ability to reactivate her law license to this day, as best I know. There was no disciplinary or anything of that nature. It was just her deciding to make her law license inactive. And then at the time, she was also working in Ohio as savings, I believe it was, in a position that didn't require a law license. But I believe there is testimony in the record that when the mother had when the youngest had hit kindergarten, there were discussions, at least according to Dad, about mom returning to the workforce, whether or not those conversations were full-time or part-time. I know that the mother disputed those allegations, but then we know that she filed the divorce itself, I believe it was in October of 2013. And so by the time the case came for hearing, she had approximately a year to seek employment. I know that she indicated that she had applied for 100 to 200 positions online. What those positions are, the job qualifications and so forth, right now.
Would it be your position if, for example, she felt, for whatever reason, personal or otherwise, that the stressful position as an attorney would not be what she would want to do at that stage in her life? Would you say that nonetheless she should be faulted for making that decision?
I'm not saying that she should be faulted for making that decision. However, it also, two things. One is it should not be counted against my client, who at this point has put in every portion of the income itself into the calculations. But the second thing is that when they were evaluating job positions, the expert, Mr. Anderson, had specifically looked at other positions that may not be
Like loan
attorney.
closer and some of the others?
Yeah, loan closer, I believe, paralegal. There was also some other type of position, but he also factored it in both the Akron market and the Cleveland market, which I thought was rather ingenious to make sure that there were a variety of positions covered. But in this case, what we have is that there seems to be, and I'll say it, inability versus unwillingness. There seems to be an unwillingness to work. There's nothing in the record that indicates the mother is unable to work, that she is, it seems to be more of an unwillingness to engage actively in the process and to seek employment. The only employment that she had, according to the record, since they were married, was obviously she was the attorney at the very beginning of it. And I can some days completely understand why people don't want to practice law. And yesterday was one of those. I can understand that, but there are still other avenues of employment.
And as to that, I think I read in the record, in the briefs, that she had made a substantial number of applications.
Correct.
For other alternative and suitable employment, but had not, for whatever reason, it's not in the record, it doesn't tell us why, she didn't get any employment.
I would agree that the record shows that she had applied, that she indicated that she had applied for jobs. Whether or not those were suitable, I'm not sure if I would agree with, because I don't think that there's an indication to the type of jobs that she was applying for.
I'm sorry to interrupt, but my understanding is they were online applications?
Correct, Your Honor.
Was there evidence presented to show that she made the application and was rejected?
No. No, it was just purely based upon testimony. And if I go back to Judge Whitmore's question, when I say applicable or appropriate jobs, we don't know what the types of jobs were she was applying for. So, for example, if she's a licensed attorney with a degree in political science, which is what her background is, if she's applying for a job as a chemical engineer or something of that nature, obviously she's not going to qualify for a position, or for, like, let's say,
I don't think I don't think the record would support that either.
Well, but the record I don't think shows what the positions were or what the rejection reasons were, but the record does show, through the testimony of her witness, Mr. Anderson, that if she had applied for that number of positions, and I'm not doubting her estimate, that and only gotten, I think it was like three or four interviews, and no job offers, that something was going on there that wasn't making it sink, and that she should have been able to locate at least an offer, if nothing else. But my understanding is that Mr. Anderson, that you had a chance to review her resume to see what the flaws were find a job, but his purpose was actually to evaluate her skills and see where she would be falling under an income line. And the income line that she fell under was way in excess of the $27,000 that she had paid previously back in, I think it was 2000, was last year. The problem with that calculation also is, I am not saying that they should have attributed her as if she had been in the workforce during that entire period. What we are still looking at is an attorney with the ability to reactivate her license with, we'll call it under a year or two of practical experience. I'm not saying to attribute her as if she was, I believe the math is correct, would be a 16-year practicing attorney where she would be financially adaptable. But she should at least be evaluated based upon what the evidence shows through the testimony is what her real income could be. And the numbers that were provided were probably pretty, I would say, pretty conservative actually, if we're looking at what her potential earning would be. So given that, that's where I believe that the court, the testimony and the numbers that the judge used in his assessment to come to a zeroed out contribution level from her was an abuse of discretion. I think it was completely against the evidence in this case. And so,
you're starting your rebuttal time. If you'd like to save or continue, that's up to you.
I would like to save my rebuttal time if I can.
Thank you.
Thank you.
May it please the court, my name is Leslie Grasky. I'm here on behalf of Mrs. Sayoc today. I think that it's clear that there is evidence that could go both ways in this record. However, the law in Ohio is clear that the issue is whether the trial court clearly lost its way. The trial court did not clearly lose its way. It's long been recognized that the trial court is the one that has the best opportunity to have contact with the parties and to observe the parties, to observe their demeanor, to listen to the answers and the way the information is provided. And that is why, for a very long time, it has been held that a reviewing court is to give deference to the findings of the trial court. Excuse me. The presumption in favor of the trial court's findings has never been overturned. The wife testified not to $2,000 a month in child care. That is actually a significant issue because in November, well, actually November is not a good example. February, you may not have $2,000, but you have summer, you have winter break, you have spring break, you have institute days, you have 3-day weekends, you have sick days for the children, you have a lot of extra days that fill this up. The wife testified clearly and succinctly about looking at care.com and at KinderCare. And she testified as to the varying prices, and the ultimate determination was that it would be $24,000 for a year for all of the parties' children.
But was it specific as to, like 3 hours a day?
No, she did discuss that it would be before and after school care. The parties had not been functioning well as a set of parents who could do offsetting, I'm going to cover this day and that day. There was no evidence of that being an option. And if the husband wanted to cross-examine, he could, and he did not. And if he wanted to present contrary evidence, he could, and he did not.
And I appreciate that, but,
Yeah.
just on its face, it does seem a little excessive, $500 a week, basically.
And again, the problem is it's not $500 a week all year round. It's actually more during the summer. When you have 3 children, childcare is very expensive, particularly if you're expecting the wife to go out and find an attorney job, where you don't have the guaranteed, I'm going to be in at 8 and out at 5. And regardless, that's the only evidence that was there. And it is not so clearly specious that the trial court should have rejected it with no opposing evidence presented whatsoever. I think that's a significant issue.
This is not a case in where child care at the normal institution would have been inappropriate. The children weren't special needs.
No.
They didn't. This is
No.
a standard case.
No, it's just there were varying ages and varying schedules, and that can make it difficult with your in-home care, and it can make it very difficult with your out-of-home care when you're having to do all of the switches. And importantly, everything the trial court ruled on concerning the wife's employment and the child care costs is subject to modification. This was the judge looking at all of the evidence, listening to the parties, and saying, when I look at everything, the child care would eat up the vast majority of her income, considering all of the jobs she had applied for. There's no evidence she applied for a chemical engineer position. There is evidence that she very much wanted to work and not live support check to support check without enough money to take care of the children's needs. She was expressing difficulty on how she was functioning on the temporary orders. She wants work. And when there is work, we'll have a different situation, and we can look at exactly what the real costs will be. It's not error for the trial court on a modifiable spousal support and child support award to make the findings that it did on the state of the record that is actually before the trial court. Very important. As to the underemployment issue, again, the wife testified extensively as to her efforts to look for work. There was an expert who spent a half hour with her. He didn't provide her with any of the job leads. He provided the trial court. He did not testify that she was qualified for all of them. He specifically testified, excuse me, that oftentimes he could only find one lead that had a salary attached to it. He testified that he didn't know whether she was capable or qualified for the jobs that were on the list he presented to the trial court. He testified that wife needed to upgrade her computer skills. And then he averages paralegal, loan closer, and attorney incomes, which, I mean, that's a nice concept, but this court has rejected the trial court's averaging of business appraisals. The trial court is supposed to find an income, and the trial court did, based on the wife's testimony and her earnings history. She has not worked for 13 years at the time of the trial. She had done a part-time job during the pendency of the litigation. The expert didn't consider her earnings history. He didn't look at how long she had been unemployed. He didn't think about the fact that law firms don't want to hire a lawyer as a paralegal who's going to leave as soon as she can find lawyer work. The market has significantly reduced loan closer jobs. He used this market of 50 miles for somebody with children at home, for whom she is responsible. It's not unreasonable for the trial court to have rejected that testimony where there is clear evidence by the wife of what she can earn and how much effort she had spent to try to find work. Again, the child support and the spousal support awards are subject to modification. They can be adjusted when there is a change in circumstances. They could even be adjusted if there had been a substantial period of time with no change, if the husband were to present evidence that she hadn't looked for work. That would be a change from the state at the time of the trial. With the evidence that is in the record and the responsibilities the parties assumed during the marriage, it's not unreasonable for the trial court to find that this wife's income ability would be almost completely consumed by child care at this time. This matter is subject to further review on a change in circumstances. We would ask that the court affirm the trial. Thank you.
Your Honors, I want to disagree with Ms. Gratzky respectfully. There is testimony in the record that mother had not attempted to engage the services of father in assisting with the child's needs. And I'm pointing specifically to pages 35 and then 58 through, I believe it's 59 of the record, in which she indicated that the reason she didn't was because, and I quote, that he typically has always gotten home extremely late. But if you cross that with the father's testimony, there is an indication in there that that he does have the ability to work flex hours, and thus he could be able to work from home remotely, things like that.
Is there any evidence that father
I don't think that was ever brought up.
Okay.
Okay, and I mean, that's just, in all candor, I know that there is testimony about him being engaged in the children's lives. I know that coaching soccer, I think, is the one that specifically pops out in my head, and so that there is, but I don't think that he had been provided with any information of this is what the childcare costs are, and this is how we can adjust them or anything of that nature. To just say it is $2,000 a month or $500 a week, as Judge Carr pointed out, is insufficient, especially when we're looking at how are we setting this. And I understand that we can go back and we can ask the court to modify it, but the problem is that the numbers that were used by the court are going to form the baseline of any motion to change or modify child support. I don't think that this court or any other court has ever said just because you can go back and modify it in the future means that necessarily that the fact the court did not do it right in the first place is correct. But there is testimony that she did not ask that, and I don't know if that was just a shyness issue or a non-confrontation or anything of that nature. But there is testimony from him he could have assisted with it, so I think the court should factor
My
that in.
question was, he said he could have assisted with it, but did he specifically say to her, I know you're pressed, you're trying to find a job, childcare is costly, I'll commit to being home after school.
I would agree with that premise. Well, first of all, it's not in record, we'll start with that.
Okay, well then,
But second of
we
all,
don't need to discuss it. but-
well, the second thing is that there is testimony in the record that the kids had never been in childcare. And so the issue of cost of childcare had never come up. I think until this divorce proceedings had come up. And so, you know, to be honest, I know when I became a parent, my sticker shock from childcare was tremendous. And I'm sure that probably there's some other folks in this room that have had that issue too. And so I don't think the topic ever came up because it was never a reason for it to come up. The dad does have the ability to work and support. What I would also indicate is that if we look at the report from the expert witness, Ms. Cressy pointed out how there was an area of 50 miles for the jobs. He did indicate that there were jobs available, but he was looking at the county or the metro areas. So, for example, he spoke specifically focused in on the Akron metro and the Cleveland metro. Those are the two metro areas that would cover the area surrounding Twinsburg. And the expert himself actually gave an average income, which I think is what Mr. Skidmore placed in the brief. But he did break down what the various ranges would be. So, for example, he didn't just take an aggregate and say, this is what the average for all of these, if you lump them together, was. He did use that number, but he also did break down what the averages would be for each specific position. So, for example, what a paralegal, the average salary would be in the Cleveland versus the Akron markets, what a loan processor, things like that. And I think what the conclusion is that there is ample opportunity out there, not only ample opportunity, but also the qualification set does fit. And I think he indicated
And
his
counsel all
methodology.
the time.
Okay. And so I would just ask support to send it back to Judge.
Thank you.
Thank you.
The court will take the matter under advisement. A written opinion will issue and be sent to both sides, as well as you can look on the Supreme Court website and our own website.
Thank you, ma'am.